This is Organized, the Business Law Breakdown, and I'm Professor Seth C. Oranburg. We're talking about corporations, and we're going to focus on corporate governance. Who's actually running the show inside a corporation? We've already learned that the bylaws are the rule book for how a corporation functions, but there are some general rules that corporations usually operate by. And if you think it's the shareholders, the owners that run the corporation, I have some news for you. Shareholders own the company. They don't manage it. They might happen to be the same people, but that's really rare because one of the major virtues of corporations is the stratified management and a separation of ownership and control. The job of management falls to the board of directors at the high level and then to officers and to people they appoint. This episode is just a high-level preview of corporate governance. The rules in detail will be covered in an entire season. It's an entire season of this podcast, and frankly, could be an entire podcast on its own. There are entire courses on corporate governance. So we're just going to scratch the surface because my goal for you is to understand how corporations are managed, governed differently than partnerships, so we can pick and choose between the major forms. So what's corporate governance? Well, corporate governance is the system of rules and practices that direct and control a corporation, and it's about who makes decisions and how they're held accountable, because they are fiduciaries who are in charge of someone else's money. In a corporation, decision-making is split into three groups. Shareholders who own the company but don't run it, they just appoint the directors. The second group, the directors set broad policy, strategery, if you will, and they oversee management. And then they appoint officers who handle day-to-day operations. Why don't the owners call the shots? Well, again, that's one of the defining features of the corporation and one of the reasons why society agrees to grant them limited liability, unlike partnerships. The board of directors is the top-level governing body of a corporation. So they make big decisions like hiring, firing the CEO, approving mergers and acquisitions, although those often need shareholder approval as well when they're of a certain size, and declaring the issuance of dividends. They don't actually have to pay their dividends. Not all the time. Boards don't run the day-to-day. They have the ultimate power over management, but they act in a high-level role. When they fail at that job, the lawsuits can start flying, and we'll talk about those lawsuits in an entire season where we talk about shareholder litigation. Legally speaking, for brief, directors owe fiduciary duties to the company and to its shareholders, so they can be sued either for violating their duties to the company or their duties to shareholders. We'll talk later about direct and derivative actions, which are related to that difference. And those two duties are generally regarded as consisting of the duty of care and the duty of loyalty. The duty of care means directors have to make informed, rational decisions. The duty of loyalty means they have to act in the best interests of the company and not themselves. If they breach these duties, the shareholders can sue. So in Smith v. Van Gorkum, a case we will certainly talk more about, the board rubber-stamped a merger without evaluating it carefully. They got sued and they lost. Can't just rubber-stamp things. They have to actually read these long and boring documents, so they have a job to do. And one of those jobs is to appoint the officers and set their compensation, another interesting topic we'll talk about with the Disney case in particular. The directors will appoint the CEO, who is usually the face of the company, is the chief executive officer, the CFO, the chief financial strategist, the chief operating officer, there might be a chief technology officer. The officers actually run the company on the day-to-day basis, not the directors, who again are not empowered in their individual capacity. Directors only have power as a board, but these individuals, like the CEO, that's a person with real power by virtue of that role. Officers are employees of the company, so they can be fired. They also receive W-2s. They get paid a salary. Directors are not employees. Again, they can be both. There can be overlap, but that's an additional concept layered on. By virtue of being a director, you're not inherently an employee of the company, and you don't necessarily get paid either. And employment of officers is one way to hold them accountable, because if they mismanage the company, in theory, they can be fired. You know, in reality, boards and CEOs are pretty cozy. They tend to play golf at the same country clubs and go to each other's kids' birthday parties. and executive pay packages can be out of control. So executive compensation is one of the most controversial issues in corporate governance, which we'll return to later. Which brings us to our third category, which is the shareholders, who are mostly silent owners. Shareholders own the company, but have very limited control rights. They basically just vote on major decisions, most notably, who are the directors. And that happens at the annual meeting, if not more frequently, but most companies just have their minimum requirement of an annual meeting. The shareholders also have rights to sue, and we're going to talk about shareholder litigation in a whole season on that topic, a whole module. And shareholders can generally sell their stock, although the company isn't public. It might be difficult to find a buyer, but they can sell their stock if they don't like how things are going. And that's about their only rights: vote, sue, and sell. Again, most shareholders don't actually control the company, but there are some powerful investors that have huge voting blocks. You might have heard of some of them: BlackRock, Vanguard. They own vast chunks of stock, and they actually influence board decisions because they have so much sway over the market. Retail investors like you and me, you get a proxy statement in the mail, and you could vote online.
Most shareholders just don't bother sending in the proxy. So where does the legal framework of corporate governance come from? Corporate governance rules come from, well, predominantly state law. And the big state law here is Delaware. Delaware's General Corporation Law, the DGCL. There's also the Model Business Corporations Act, which has been adopted in whole or in part by most other states. For publicly traded companies, there are stock exchange rules. The New York Stock Exchange and the NASDAQ set governance requirements with minimum number of committees and people who serve on them. And the Securities and Exchange Commission has regulations that require certain financial disclosures and transparency on executive pay. Some of the key legal provisions that you should note are DGCL Section 141A, which says that the business and affairs of every corporation shall be managed by or under a board of directors, and DGCL Section 102B7, which allows corporations to limit directors' personal liability for managing badly. It's also notable that Sarbanes-Oxley, which was a 2002 act passed after the Enron scandal, increased board accountability. But at the end of the day, corporate governance isn't just about following rules. It's about following rules in order to balance power between shareholders, directors, and officers in a way that keeps companies running smoothly. Corporate governance isn't just legalese, and it's not just boardroom drama. It turns out to provide the rules of the game for a battle for major corporate debates. For example, there is an ongoing debate as to whether corporations should prioritize their shareholders, who are its owners, and returning profits, or whether it should take care of all of society, or at least all of its stakeholders, like take care of its employees too. The old school view says profits come first, shareholder wealth maximization. But ESG principles, environment, social, and governance, and stakeholder theory argue that corporations should consider employees, customers, and broader society too. These are things that get decided in the boardroom. Another question is, should CEOs also be given board chairs? It's not uncommon for the CEO to also be the chairman of the board, but some say this gives too much power to one person. Others say it provides a strong leadership where you have one person who is responsible for organizing the meetings and the organization itself. And another question would be, are activist investors good or bad? Activists like Carl Icahn push for changes that can shake up companies and can unseat boards that are unproductive. Some say they create value, but what value? Short-term value, long-term value, value to stakeholders, value to stockholders? When you start unraveling the puzzle, you realize there are a lot more questions than answers. What corporate governance does, it provides a framework to answer these questions. I'm Professor Seth C. Oranburg, and this has been Organized. Thanks for talking about corporate governance basics today.